and would allow the states and local governments to continue to say, okay, we may have a special problem, maybe with a particular kind of gun, or maybe with handguns, and we should be allowed to move farther, perhaps, than the District of Columbia was allowed to do as a result of the Heller decision. There'd be more flexibility, more freedom for the states and local governments to make the decision that really fits their circumstances with respect to the control of particularly handguns.
There's a deep irony here, by the way. I don't know if your audience will be interested in this, but there's a deep irony. I mean, this selective incorporation process that I was talking about was generated from the left on the court. It was the Warren Court.
Right, all the big civil rights cases.
All the civil rights.
Right.
Well, you can call them civil rights cases, or you can call them anti-federalism cases. I mean, you can give different cast to these. So it was the left, you know, the Warrens, blacks, marshals of the world that were adopting selective incorporation in order to extend individual rights. It was the right, the conservatives, that were objecting to this precisely because of its inconsistency with this notion of federalism that Don was just explaining a second ago. Well, now, you know, now the positions have reversed. It's the conservatives whose political agenda would be furthered by absorption of the Second Amendment into the Due Process Clause, because it seems to be an association between the NRA and gun users and conservative politics. So
and that's not the first time that's happened on the court or in Congress, where the two sides seem to have changed positions, depending on what fit particular moment.
So with the switch in positions, and with Sandra Sotomayor coming onto the court this year, what do you think will happen in the case?
Well, it's interesting. She sat on a Second Circuit decision. What was it? The Maloney case, I think, that involved whether the Second Amendment was absorbed, this selective incorporation, and decided with the majority there that at least it was not for a federal court of appeals to make that decision. That was for the Supreme Court if it wanted to reverse or to do something like that. And so I don't think we have any terribly good idea. Ron mentioned earlier that she was a former prosecutor. It's very interesting, not uniformly, but very widely. Law enforcement people, certainly in this state and throughout most of the country, beg for the right to have restrictions, particularly on handguns. And most of them did not like the Heller decision or the possibility that it would then be extended to the states and local governments. And we find in Illinois, for example, that whenever there is legislation pending or being debated about gun control generally and handgun control in particular, usually the chiefs of police and the prosecutors and all the law enforcement people are in Springfield saying, please, please help us out with this.
I think in terms of your question, it's just, I don't have any basis to predict it, actually. As Don says, the decision that Sotomayor was engaged in is meaningless because she was acting as an appellate court judge, and she was bound by what the Supreme Court has or hasn't done. But this dispute, which is, again, sounds a bit arcane, but critically important to the meaning of the Constitution, this selective incorporation dispute, was one of the most hotly contested issues in the late 60s through the mid-70s, when the Supreme Court then was doing all these things, and then when the political process reacted against it. And that was part of what led to the conservative trend in the United States. But that, for 30 years, has been viewed as a settled set of issues.
Right.
So there have been really no discussions on the Supreme Court as to the merits or correctness of selective incorporation versus other means of interpreting the Due Process Clause. So we don't have any of the present sitting members of the court that were ever engaged in that discussion directly. So I don't know what Scalia will do. I mean, I would think selective incorporation would be anathema to somebody like Scalia.
I would too.
But at the same time, so too is changing precedent and not following the path of the law, and the path of the law is pretty clear. here. So I think it's going to be really interesting. I think it's completely unpredictable.
I think
what
that's the sort of underlying or maybe overarching federal constitutional issue. But there's also I think it's taking a lot of people a while to get used to the Heller decision itself, because it was very widely believed by a lot of people that the Second Amendment itself did not incorporate an individual right to bear arms, and it was tied to the militia part of the, and that was the argument, by the way, that Justice Stevens made in his dissent.
Right.
Yeah, and what would it mean, Dawn and Ron, for Chicago, if the court were to rule the same way that it ruled in the Heller case here and declare the ordinance unconstitutional?
Well, I think that ordinance would be unconstitutional. The court decision in Heller did make it clear that the states and local governments were not completely bereft of the opportunity to pass some control laws. In other words, no part of the Bill of Rights is absolute. And Scalia mentioned a couple of possibilities that, maybe, well, restricting access to guns with respect to felons, perhaps the school zone argument, which is incorporated in a lot of cities and a lot of states. So there's some things that could be done.
And there are certain types of guns that probably could be banned in any event, like assault weapons.
Maybe assault weapons. One thing that I guess would happen is that the city's ability to basically to conscript guns and destroy them, and I think the last figure I saw was at something like 28,000 handguns a year they get a hold of and conscript. Some of those, I assume, they simply would not be able to get. Now, if they were in the hands of a felon, I would assume they might still be able to confiscate the handgun. But it's going to change the dynamics of that. So.
But these possibilities of regulation are only indirectly related to what the central problem is. I mean, the central problem is the cheap and easy access to guns.
Absolutely.
And so, for example, it's one thing to restrict a felon from using the gun, but that's always an after-the-fact consequence. If you got to catch them using the gun before you can do anything about it. And secondly, there are a lot of people who haven't got felonies on their records who will be able to walk in and purchase cheap and readily available firearms and then commit the first felony.
Well, and as I know, having been in a state legislature where one half or maybe two-thirds of the state doesn't believe in any restrictions on any kinds of guns, it's a very emotional issue on the part of a lot of people. And my guess is that if the court does decide that the Second Amendment is incorporated, that number one, there's going to be even more activity in state legislative bodies on both sides to find those few areas where we can still regulate particularly handguns. And on the other side, I think the argument is going to be made that the Supreme Court has said that there's a perfect right to have a gun, so you can't do anything. So that's going to be a pretty brutal battle,
We'll watch that case really closely, I think. I'd like to thank you both, Dawn Clark-Netsch and Ron Allen, for being with us here today. Thank you for being our guests on Chicago Bar Association's Justice and Law Weekly. I'm Terry Masherin. Thank you for watching.